Hello, this is Chris Heasley with the Chris Heasley Radio Show. And on today's show, we're going to discuss the Texas Court of Appeals and the critical role it plays in defending intellectual property rights. And so I'd like you to think about this. There are 33 million people in Texas, and this state economy is incredible. It's explosive growth. And 33 million minds, the brain power of 33 million people combined with this incredible economy means that innovations and new ideas, new technologies is going to be robust. It's going to always be coming. But what good is it if it's not backed by a strong defense of intellectual property rights? Only with that strong defense, that bedrock, that laying that foundation of intellectual property rights, the defense of it, will we truly allow our economy to grow and allow our best minds to develop with the greatest innovations that we can see. And so that's the purpose of today's show. We're going to get in that and other things regarding the Texas Court of Appeals. And on today's show, we have Malcolm Whittaker, who will be discussing these things and other things with us. And Malcolm Whittaker is a candidate today for the first Court of Appeals in place 3 for the Texas Court of Appeals. And Malcolm, how are you doing today?
I'm doing very well. Thanks for having me on, Chris.
Thank you for being on the show. So if you could just start out by telling us what is the Texas Court of Appeals and what role does it play for Texans, for us in the state of Texas?
So the first Court of Appeals is one of the 15 Court of Appeals in the state of Texas. And the Court of Appeals reviews all of the legal decisions of all of the trial judges in its geographical area. So in the case of the first Court of Appeals, it's a 10-county area, 10,400 square miles, 7.1 million people. And maybe this isn't good radio, but it's Chambers County, Waller County, Galveston County, Brazoria, Harris, Fort Bend, which you're most interested in, Washington, Grimes, Colorado, and Austin counties. 10 counties. And so all courts of appeals review the legal decisions of all courts in that area, in those 10 counties. And that's civil, criminal, probate, family, everything. So effectively, the Court of Appeals for those 10 counties is the final stop because the Texas Supreme Court takes less than 100 cases a year. So effectively, whatever the Court of Appeals decides is the end of the line. If you don't like the legal decision, your chances of being heard by the Texas Supreme Court or ultimately by the U.S. Supreme Court are very, very low. So it's the final stop on the station, effectively.
If I'm in a district court in the counties in the first Court of Appeal in the counties that you mentioned in that geographic area, and I feel that the decision was given to me was unjust on either the plaintiff side or the defendant side, I could be on either side of that aisle. I can then appeal to the Texas Court of Appeals and have them rehear the case. Is that correct?
So it's not rehearing the entire case. It's determining if the trial judge determined the law correctly. So if there's a factual dispute, which car ran the red light, the Court of Appeals doesn't review that. If there's a legal dispute, for example, a fire engine has legal authority to run through a red light as long as its sirens are on, right? That's a legal question. So whether the fire truck had the legal right to go through the red light, that's a legal question, and the Court of Appeals can review that decision.
Whenever I go in front of attorneys, they always inject a sense of self-defeat in me. Whenever I've been in any legal dealing, they always sort of present it as an uphill battle. Well, Chris, you may. They don't even say you have a strong case. Even when I do, they talk about how I'm going to lose, and I find that very frustrating. I mean, can you just explain why attorneys do that? What is it, to set expectations or what? Why? Because then the other thing is that
the other thing I notice about attorneys is that they never want to actually go in to do legal battle. So what they do, you go in front of them, they start to, powder puff you with ideas of defeat and try to get you to either close out the file or compromise. But I find that very frustrating with the legal system.
Well, I can understand that. I mean, what I have, before I became a lawyer, I was an engineer. I went to engineering school and I studied mechanical and aerospace engineering. And that subject matter has very hard and fast answers, right? The circulation around this wing form is 42 pi radians, okay? In the law, it can be a lot harder to give a definitive answer. And I think the reason that lawyers do what you're complaining of is that they want to manage expectations, in the sense of, if they tell you, oh yeah, you're going to win for sure, and then you don't, then you're disappointed. In my case, I think you have to advocate for your client and, rely on your strong facts and make sure the law is on your side.
With the Court of Appeals, they're overturning a district judge's ruling. And of course, we treat district judges like they are, almost like gods. And does the Court of Appeals ever have that sort of bias where they look at it, things appear that they should be overturned, but they don't want to step on the toes of a well-known, prominent district judge? They're going to embarrass him. It's going to look bad on his record. His image is going to be hurt. Is that barrier in place, that unsaid barrier in place, when the Court of Appeals is reviewing a file?
Well, judges are human, just like everyone. And I'm not a judge now. I'm running to become one. I think that there's no way that in the back of someone's mind they don't have some inherent predisposition, and even if they try and overcome that, I think if there's a trial judge's decision, inherently people don't like to disturb the status quo. So even if the trial judge got it wrong, I think inherently Court of Appeals judges say, we're gonna leave things the way they are. I'm also admitted in North Carolina, and they have a single unified Court of Appeals, and the nickname of the Court of Appeals there is the Court of Affirms, and an affirmance means we're gonna go with what the trial judge has already done. So I think there's some correctness to the statement you're making.
Yeah, again, I feel like what I'm trying. I guess with my previous two questions, what I'm trying to display is that as a commoner going into the court, as an everyday regular citizen, I always feel like it's a fraternity, a social structure that I'm on the outside of, and I have to put a lot of money down and keep my expectations very low, and that just always feels unjust to the everyday common citizen. So I'm just expressing some of my frustrations with the legal system there for you. So,
no, I get that, and it's expensive. It's expensive to go to court. I'm arguing an appeal on Wednesday, and if it's a case where, and this may be to regular folks, you may say, why is this important? But this is a case of first impression. It's whether insurance coverage protects against a claim concerning trademark and trade dress and dilution of trademark right infringement. Right now, and you could say, how can anything be more boring than that? But for this client, that is vital to their business. And for thousands of businesses across the state of Texas, if you get sued, does the insurance for allegedly infringing somebody's trademarks, does that insurance company have to step up to the plate and defend you? Because being sued for a small business that's just getting going, frequently it can destroy the business. You just run out of money. You can't pay the lawyer and run your business.
Oh, wow. Well, I want to hear more about that, but first, before we get into the real deep issues of the Court of Appeals, that story
Yep.
sounds fascinating. Can you tell us about yourself? What's your background?
So I'm married. I have two daughters. My daughters I've got a daughter who's a sophomore at William and Mary, and I've got another who is a junior in San Antonio at Trinity University. They both take after their mother. They're very smart. I wanted to be a naval aviator, and I had my nominations to go off to Annapolis, and I had passed the medical, and I thought that I was going to go to the Naval Academy, Annapolis, and be a Navy officer and be a flyer, and then I unpassed the medical, for lack of a better term, and a friend of mine's mother had said, "You better apply to NC State, North Carolina State University, because what happens if you don't go into the Navy?" And so I applied, and I ended up studying mechanical and aerospace engineering at NC State and graduating. And while I was doing that, I've always been interested in history, and I did a double degree in mechanical and aerospace engineering and history. And it's actually a funny story. There was this is long before I was married. There was a young woman, I overheard her saying that she was going to the graduate school fair, and I thought maybe I could just run into her at the graduate school fair. And so I went to the graduate school fair, and I positioned myself next to a table where I could see the entrance, and it happened to be the table for the University of North Carolina at Chapel Hill Law School. And I was standing there watching for this woman to come in. And so the law school person started talking to me, and a couple of my professors had said, "You should go to law school. You write so clearly and effectively." I think my history professors meant that as a compliment, but my engineering professors may not have meant it as a compliment. And anyway, before I knew it, I had signed up for a tour, and I went over to law school, and a week or two later, and I applied early admissions, and I got in. And I did run into the young woman at the graduate school fair, and we dated for a while, but that was never going to work out.
Very good.
I worked, after I had worked for a firm in Manhattan, a big firm in New York, and then they lost a verdict. I graduated from law school in 1991. It's sort of interesting. I still think of myself as a young lawyer. I was in federal court a year or two ago, and the judge said, "Well, the door to the courtroom opened. It was a huge courtroom, and I hear hundreds of feet coming in." And the judge says, "Oh, don't worry, counsel. I've invited some law school classes to watch two very senior and experienced lawyers argue." And I said, "Oh, really? Can I stay for that? That I might learn something." And the judge looked at me like, "You're just toying with me." And it turned out that had like several hundred law students come to watch me and another lawyer argue. And anyway, it's so I've been a lawyer since 1991, and I've worked small firms, large firms. I've had my own practice. I've even been in-house counsel for an oil field service company. So I feel like I have very broad experience in the law. And I have focused my practice primarily in what you were talking at the opening of the show, intellectual property, which is patents, trademarks, and copyright. And that affects 44% of the American economy, $13.4 trillion a year. It's a vital part of American law. And there's no one on the First Court of Appeals or any Court of Appeals who has any specialized knowledge about that area of law. And that's why I would like to join the court.
So tell us about your work prior to today, your work in defending intellectual property rights?
So it's more than just defending intellectual property rights. What it's doing is having the proper bounds for intellectual property rights. For example, a plaintiff can overstate their claims, right? In the law, and maybe I'm getting too much into the weeds here, but judges have to have trial judges, the district judges that hear the cases initially, have to have some guidance on how to decide cases. There's a doctrine in intellectual property law called famous marks. Now, famous marks are marks like Coca-Cola, the Olympic rings, that are known all over the world. I did a case not too long ago where there was a doctor who had a very small practice, and she asserted that she had a famous mark in the use of the word memorial. Now, last I checked, Memorial was an area of Houston, and she claimed that she had exclusive rights to the word memorial, and because her use was famous, that she was known all over the world for this. Now, my client spent a huge amount of money fighting over this, and the judge would not throw that claim out. So protecting intellectual property is important, but you also have to give trial judges guidance as to, are they letting the claimant ask for too much, right? That case should have been thrown out from the very beginning. There's no way. It's like you, Chris, trying to claim exclusive rights to the word Chris. Well, there's lots of Chris's out there. You can't say no one else can be Chris. So the trial judge said, well, there's not really any good case law on this. I'm just going to let it go to trial. And so, that judge made a very poor decision, and that my client, had to spend an enormous amount of money to defend against that meritless claim.
Well, I think that goes to show your point that there's a lack of an understanding of intellectual property in our court systems, in our legal systems.
Exactly. And it's so vital because people build businesses based on intellectual property. And in many cases, other than the hard work and sweat and effort of the business owners, the intellectual property is the asset of the company. It's not like the old days where you own, 1,000 miles of railway track and railway engines. Now you own the patents or the trademarks or the copyrights on how to on doing something.
Okay, so let's explain to the everyday common average person what actually is intellectual property and intellectual property rights.
Okay, fair enough. So intellectual property, the way you protect it is one of really four ways. The first is a patent, and you get a patent by filing a patent application with the U.S. Patent Office,
And the patent essentially protects an idea.
Well, it protects. In a very broad sense, it protects an idea. You have to have more than an idea. You have to have the way you carry it out or the structure that you use to carry it out. I'll give you an example. I was up in the Court of Appeals. Well, this is going back to more than a couple of years. I defended a company that had a patent that would have prevented the oil spill in the Gulf, the Deepwater Horizon. It was a monitoring system, and for determining if there was a blowout, right? This patent would have prevented the Deepwater Horizon blowout. Now, it wouldn't have prevented the leak, but it would have prevented it from spreading because it would have closed off the wellbore, right?
So in other words, the minute that the leak springs, something comes in to insulate, to segregate that part of the ship and stop the flow of oil happening.
Well, actually, it was there's the patent had a method of detecting if there was an unexpected flow of oil anywhere outside of where it was supposed to be, and then there's a thing in at where the oil well is attached to the bottom of the ocean, and there's a thing called a ram, and it closes the well bore off. Now, the danger with that is that let's say you get one drop of seawater in there, you don't want to close the ram because that's permanent. That's like chopping off your hand. If you have gangrene, they chop off your foot to make sure that it doesn't spread. Well, you don't want to do that if you
It
get a
shuts down
nick
the
on
well
your
forever,
foot.
is what you're saying?
It shuts down the well forever. So you don't want to do that if it's not a real problem. And the way what this did was is it essentially made certain it detected if there was an abnormality, and then if the abnormality was serious and uncontrollable, it would close the ram and shut the well down permanently, so that all those millions of barrels of oil didn't spread into the Gulf or wherever you were.
So it was able to measure the degree of the threat, and if it was substantial enough, boom, the well gets shut off.
Yep, exactly. Brilliant idea. Brilliant idea. Very important idea. And the U.S. Supreme Court, a year or two before, had issued a decision that said things that are essentially methods of, they call them abstract ideas, methods of doing things that could be done by human computation cannot be patented. And so they said that this patent never should have been granted, and they ruled against my client, and we took that up to the
I'm
Court
sorry,
of
could you repeat
Appeals.
what the Supreme Court's justification was?
They said that anything that could be done by a human using a piece of paper doing a calculation was no longer patentable. They called
were
it
they
the
paid off for that
abstract
one? I mean,
idea.
that's absurdity.
I absolutely agree with you. It is an absurdity, and that was a judge-made rule. I think there was a concern that a bunch of patents were issued in the early years of the internet on basically doing things on the internet, doing banking on the internet.
So
Doing.
it was blowback from a sort of like an exaggerated use of patent in law when it shouldn't have been
Yes.
done. So now they're kind of clamping down a little bit too much.
Precisely. You've stated it better than I have. And my client spent a fortune on that patent. They spent a fortune building a business, and a competitor popped up, and we sued them, and we lost on the basis of what they called it the abstract idea doctrine, and we went to the Court of Appeals, and there's only one patent lawyer on the whole 15-member Court of Appeals that sits in Washington, D.C., which seems ridiculous that you shouldn't have a bunch of patent lawyers deciding patent law cases. And we went to the U.S. Supreme Court, and they declined to review the case. So that's a problem. That's not a problem I can solve on the Texas First
So
Court
real
of
quick, that
Appeals.
technology went down the drain. Flush it down the toilet. It's gone.
Well, the client didn't go out of business, but they weren't able to prevent their competitors practicing the patent.
Wow. Well, certainly you make the case of the necessity of an astute understanding of intellectual property rights and the defense of it is needed in the courts. So go ahead, please tell us about the Texas Court of Appeals and how we can improve that institution, that body of representatives, with your ideas.
So I'll give you an example of that, the famous Mark case, where this single doctor claimed that she had an internationally famous trademark, right? It's one doctor. I mean, one doctor cannot possibly have the same marketing power as Coca-Cola
If I
or
may say,
Google.
just so people
Yep.
understand, trademark. Trademark is, like you said, it's like your logo, your name, your identifying feature, your identifying logo and name in sort of a marketing form, like a Coca-Cola, like the McDonald's arches. And in this situation, you have a single doctor, which there's doctors at every street corner, and she's saying she's the equivalent of the McDonald's arches or, or something of that sort. Is that what you're saying?
Maybe you should have gone to law school and I should have been a radio host. Yes.
Thank you. Okay, please.
And so when the state court judge wouldn't throw that out as a frivolous, ridiculous claim, my client ended up changing their name, and they had to rebrand
And who
themselves.
was your client? So your client, the doctor was claiming that your client was using her logo, her name. And who was your client? Another doctor, or who was your client?
A small group of doctors. Yes.
So they had to change their entire marketing insignia, everything.
Everything. And go through all the expense and all the rebranding.
I mean, that's a good example of how our courts can be, they can really be weaponized when there's not an astute understanding of the law, a sober interpretation of the law, then people can really get hurt.
Yes. And these are real people, right? I mean, if two giant corporations are fighting, neither of them is going to run out of money, right? But if a small group of doctors that's just starting up, they can run out of money.
Well, I think the vulnerability there is that lawyers see small groups of doctors as an endless, bottomless pit of money and cash. And I personally know doctors that were the victim of this, a very profitable practice in southern Texas that was targeted by a law firm unscrupulously, only for a frivolous lawsuit. Truly, it was frivolous, but it wasn't thrown out. And they attacked this law firm until the law firm finally went bankrupt. Until the medical firm went bankrupt. Now, the law firm then was shocked because they had put so much money into taking this group down. They were expecting a payout, and they never got their payout. So I understand exactly what you're saying. Everyone is vulnerable outside of the mega corporations.
And if you are a young entrepreneur and this group of doctors, I mean, they're medical doctors, but, they wanted to start a practice. They wanted to, serve the public and presumably make a living at the same time. That they have weathered that storm, but I think it was nip and tuck that was actually going to happen. And if the story had to me a humorous ending. The plaintiff doctor who claimed that she had an internationally famous mark, the same as McDonald's, or equivalent to McDonald's, not the same as, equivalent to McDonald's. Her lawyers extracted so much money from her that she ended up closing down her practice. So the plaintiff ran out of money.
Yeah, I mean, in all of my interactions in the legal system, I get an queasy feeling. When I walk by the courthouses, I feel uncomfortable. It's just it's a blood sport. It's very tough business.
Well, if I can go back in history a little bit, it's in France, in pre-revolutionary France. People say they don't understand the legal system, right? It's not intelligible to a lay person. In pre-revolutionary France, pre-1789, before they deposed the King of France, there was a thing known as legal French, and it was a completely different language than French. It was like a mix of French and medieval Latin. A mix of medieval French and Latin, and it was called Law French, and you had to speak Law French in court. And so you basically, when you learned how to be a lawyer in pre-revolutionary France, really what they were teaching you was Law French, so that if you were just a regular person coming into a courtroom, you couldn't understand what the judge and the lawyers were saying because you didn't speak the language. And to me, we don't do that now. We all speak English. But to me, we need people on the Court of Appeals who are able to give guidance through the appeals decisions that we write as to how to apply the law so that entrepreneurs, business people get a fair shake when they come to court.
So tell us about some of the more egregious decisions that you've seen in our Texas legal system.
So the one that the worst decision that comes from the U.S. Supreme Court is that that abstract idea, the idea that you can't patent a method of carrying out a business practice, that was a clamp down on the U.S. Supreme Court's overreaction to patenting things like doing banking on the internet, doing paying for parking on the internet. That has, I think, damaged the U.S. Startup scene very badly, and that's almost a 10-year-old decision now, and the U.S. Supreme Court has declined to review that decision, and to me, that is hurting American entrepreneurs and American venture capital, and that's an important thing. I mean, if we are no longer the center of that, then America's economy is not going to grow nearly as fast as it might have.
Right, and I think that Texas is becoming the hotbed of technology, right? When I was my post-college years, it was always California, San Francisco, that area was the hotbed. But really, I feel like the best and the brightest minds are moving to Texas, and there's a strong need for a strong defense of intellectual property rights in our own state, not just in the country, but in our own state of Texas.
Absolutely. I mean, we're starting up a stock exchange here. Those are all very, very important things. I mean, most people don't have the money that it takes to get a significant business going. And so you bring in investors and then you go public. And if you can do that in the state of Texas, I think that's good for Texans, and it's good for business, and it's good for making us all wealthier.
Right. Earlier in our conversation in the pre-show, you mentioned a court case where there was a man who got thrown out for praying. Did I hear you right?
You did. I've done appeals all over the state of Texas, across the state of Texas, and I've done appeals in federal courts throughout the United States. That was a fascinating case to me. I got a call from a friend of mine who's a lawyer in Jacksonville, Florida, and he said, "You'll never believe what happened today." And I said, "Well, Al, tell me what happened." And there was a gentleman who it was a case that was getting a lot of publicity. It was a former member of Congress who was accused of stealing from a charity that she had set up, and the judge didn't like all the publicity he was getting. He didn't like having reporters in the courtroom. I mean, I haven't spoken to the judge about this, but I know that judges don't like having reporters in their courtroom. It's just human nature, right? You don't want people focusing in on paying minute attention to your work. And so this juror listened. I'm going to call him the praying juror. This juror listened to all of the evidence, listened to the jury charge, which is the judge's explanation of the law, and then the judge said, "Well, it's late in the day. Everybody go home and start deliberating in the morning." So this juror, the praying juror, went home, and in the privacy of his own home, he prayed about his verdict. And he came back in the morning. The jury begins deliberating, and the juror, and he says, "Well, I've prayed about it, and I don't believe the witnesses who are saying she stole the money." It was either the chief of staff who stole the money, or it was the member of Congress who stole the money. And if you believed the chief of staff, then the member of Congress stole the money. And if you didn't, then she didn't. And it was the chief of staff who was keeping it. So but it was all in cash. They were taking it out of an ATM, so we don't actually, there's no conclusive proof as to where the money ended up. But this member of Congress had raised money for a charity to give out scholarships to African American students, and they'd collected 800, I believe it was $800,000. I haven't looked at the number recently, and they only gave one very tiny scholarship, and the rest of the money vanished. And anyway, the praying juror said, "I don't think that the member of Congress did it." They asked him, "Why do you say that?" He said, "I prayed about it." And when he continued to vote to acquit, another juror wrote a note to the judge and said, "This juror is praying. He can't do that." And so the judge called in the praying juror, and I'm going to refer to the snitching juror and the praying juror. And the snitching juror said, "He can't do this, throw him off." And the judge questioned him and said, "I'm throwing you off." And it seems to me that the First Amendment of the U.S. Constitution, in addition to protecting freedom of the press, also protects freedom to practice one's religion. And, it's entirely reasonable to believe that a believer would pray about an important issue such as the guilt or innocence of a criminal defendant. I mean, the jury is going to decide, the freedom or even the life of a criminal defendant, and the jury charge ends with "So help me God." Surely you can pray about an important issue like that. Well, when he admitted to that, the judge threw him off.
What was the judge's justification? What is the crime in a prayer?
He said that it was fascinating because there's a transcript of the interchange of the talking between the judge and the juror, and the juror is saying, "I'm just basing my decision on what he called the evidences and your instructions," meaning the jury instructions. And I'll send you the brief. Chris. I'll email it to you. It's fascinating reading. It's not that long a brief. I'd be happy to send it to anybody who wants to read it. The judge's justification is that he said, "We prayed about this. That is an external influence, and we don't allow external influences." Candidly, I think that the judge didn't want to retry the case because I think this juror was convinced that the defendant was innocent. And in a criminal case, you have to have a unanimous verdict. So what would have happened is the judge would have had to declare a mistrial, and then they would have had to retry the case. And so that would have meant that the judge would have had a courtroom full of reporters for the retrial of the case, and he just didn't want to do that. He didn't want to be in the news. He didn't want to be scrutinized like that. So he threw the praying juror off, and they convicted the defendant on 18 of the 24 charges.
Man, that's a rough one.
Yes. Well, ultimately, the 11th Circuit reversed that decision and threw out the conviction. And
who was the politician? Are you allowed to say the politician?
Her name was Brown, Representative Brown. She was in the Jacksonville area. Suddenly, I'm blanking on her first name. Representative Brown from Jacksonville, Florida. Suddenly, I'm blanking on her first name.
Look it up. I know that. Keep telling the story.
I know that's not good radio.
No, it's fine radio. I'll look it up.
Okay. So Representative Brown, she actually ended up going to prison. They gave her a prison sentence, and she ultimately, she got convicted just a little bit before COVID, and she ended up going to jail. And then because she was in her 70s at the time. She ended up being released. She got released to home detention, and then we lost on the first level of appeal, and it went up to what's known as en banc review, which is all of the judges on the court, and they ultimately reversed the conviction and said it was a violation of the juror's constitutional right to freely practice his religion. And so she was, and the Department of Justice declined to retry the case, and they dismissed the case.
It's Corrine Brown out of
Corrine Brown,
Florida.
thank you.
Do you
Yes.
do you think she did it? Or were you involved in the case at all?
So no, I did that case pro bono. My friend called me and said, "You'll never believe what happened today." And I said, "They can't throw him off. That's what the First Amendment's for." And
so
so
you came
no,
in just on that matter, not on her guilt or innocence.
I did not come in on her guilt or innocence. I thought that was such a significant issue that somebody, a lawyer, had to step in and take that case up, because the Constitution doesn't get eroded. That's the whole idea of erosion, right? It doesn't get broken at one time, it gets chipped away. And I thought if we allow that judge's decision to stand and the initial Court of Appeals decision to stand, that's going to be one of the first chips in the idea that you can't pray about an important decision. And so that's why I got involved with that. I thought that was a really important case.
Do you think she was innocent?
You know, I don't think that's the right question. So the right question is, even the guilty have the right to a fair trial. I don't know if she was guilty or innocent. Either the chief, a lot of money went missing. From memory, it was about $800,000. Someone stole it, okay? Either it was her chief of staff or it was her. I don't know who it was, but we do have the idea that that ideas like constitutional protections can be more important than just whether a defendant stole money or not.
So one of the things we talked about was corruption you have a background in Indonesia, or in that part of Asia.
Yeah.
And you talked about corruption there when we were talking about intellectual property rights. Can you talk about, how did that experience in Indonesia sort of influence you in seeing this need for the defense of intellectual property rights in Texas?
Well, I actually lived in Singapore, and Singapore was a former British colony, and they relied on the common law, the British and American system of law, and they believed very strongly in the idea of personal property rights, right? If you owned a piece of land, the government just couldn't come and take it from you. The government would, if somebody was trying to use your land, you could go through the courts and you could protect your property, whether
Singapore.
It was in Singapore. And, they were determined that they were going to be a place where businesses could freely operate and be protected by law. And Indonesia, which was not very far away, just across the straits, it was an utterly corrupt country. If you wanted to get a driver's license, you had to pay a government official. If you wanted a permit to install telephones, you had to pay a government official. To me, public corruption, and let me back up. Singapore was a very prosperous place, and when I was there, it was a prosperous place, but now it's an even more prosperous place. Indonesia, if it didn't have oil, it would be a broke country. It'd be a failed state. Why is it that two countries which have very similar geographical position and resources, Singapore didn't have any oil? Why is one a successful country and one is a completely unsuccessful country in terms of rule of law and ability to start a business and prosper? Well, corruption. Indonesia, you pay to do everything. And the way to become a rich person in Indonesia was to marry into the president's family or be related to the president's family in some way. And so I looked at what I saw when I was a boy and a young man in Singapore, and I said, corruption is a cancer on a society, and we cannot tolerate that. If we, and I'm not just talking about a handful of people, if we as Texans and Americans want to prosper, we have got to make it so that if people want to start a business, that their private property is protected, and they can let the marketplace decide if they're going to succeed, not whether or not the government decides if you succeed. And that's vital. I mean, I run a business. I'm a lawyer, right? It's a profession first and foremost, but it's a business too. You run a business. We're both providing services.
Is there an issue with intellectual property theft in the state of Texas?
I think that there is to a certain extent, but there also, I think, is a bigger issue with China forcing U.S. companies to divulge trade secrets to them for the privilege of doing business in China. And so the Chinese are picking up technology which they haven't developed, and then using that against American companies and European companies for that business, and for that matter, Japanese companies. I mean, China is a huge market.
Is there anything that can be done to stop that at the local level? I know these are probably questions you don't typically get when you're running for
that's perfectly
a local
fine.
Judge position, but just putting it out there.
I think that as a Texas, I think the state of Texas could pass laws that would say a Texas corporation can't do that, can't, has to, if you have proprietary information that you shouldn't have, you are forbidden to do that, to disclose it to the Chinese partner in order to gain the privilege of doing business in China. The legislature of the state of Texas could do that. A Texas judge couldn't do that. That would be overstepping our bounds. If I wanted to get into that business, I need to run for the legislature.
Was there an issue with, and I apologize, I'm just pulling this out of my memory, foggy gray memory, but was there an issue with that the Court of Appeals stepped in regarding the impeachment of Ken Paxton or something of that sort? There was something that happened that caused Ken Paxton to then begin campaigning on behalf of new candidates for one of the court systems. I don't know if it was the Court of Appeals or something.
So I'm going to speak very broadly about this because judges and judicial candidates aren't allowed to comment on how they specifically rule on anything. But the fact pattern I think you're talking about was there was a county in Texas that there was an allegation. The Texas Attorney General made allegations that there was election fraud in that county, and the county attorney said to the Attorney General, "You don't have authority to bring these cases. Only the county attorney has authority to open an investigation into the folks who are alleged to have committed election fraud." And the Attorney General said, no, I can do that. And it went all the way up to the Court of Criminal Appeals because it was a criminal case, and there was an 8-1 decision that said the way the statute, and I'm just paraphrasing here, the way the statute is worded, the interpretation which the Court of Criminal Appeals drew, which is the highest court for criminal appeals in the state of Texas, the Court of Criminal Appeals in an 8-1 decision said that The statute says that the attorney general has to be invited by the county attorney to participate in that criminal case. And the county attorney said, I don't want the Texas attorney general involved in this case. I am not inviting the state attorney general in. And there was a huge dispute over that. And several of the judges who were on the group of 8 have primary challengers, which the state attorney general has backed.
We need to take 1 second to do my product placement here. We have a featured product, and it is the X39 patch. The X39 patch. This patch, what it does is it stimulates your stem cells. So we're all operating with foods that have toxins in them. We've had our food supply really poisoned to some extent, and as a result of it, we have somewhat unhealthy bodies. And the one thing that can save that is your stem cells by stimulating your stem cells. And this is the X39 patch. And what it does, you wear it 12 hours a day, and it stimulates your stem cells. It has incredible healing abilities on your body. Just to give you an idea, Maria is a woman in Fort Worth. She fell in the shower, hit her head. She had 10 years of headaches. She put on the X39 patch. The headaches went away. I have a friend who is a PTSD war veteran, Iraqi war veteran. He has to take serious meds just to sleep at night. He takes the X39 patch. He no longer needs those medications to sleep at night. David is a man up in Dallas who began to have spots in his eyes. He wears glasses. He does the X39 patch. Not only do the spots go away, but his eyesight completely clears. He doesn't need glasses anymore. As for myself, after 40 years old, we have that pressure on our bladder. We have to go to the bathroom all of the time as men over 40 because that pressure on our bladder, it's hellacious. But with the X39 patch, that's largely gone away with me. In addition to that, energy, it gives you energy that's off the charts. I wake up at 5 a.m., I start working on very sophisticated projects at the crack of dawn, and I don't stop until about 11 o'clock at night. And it's the X39 patch. And you can learn more about this or receive a discount on it by texting the word Patriot to 330-606-2304. Well, okay, last question I want to ask you here to finish up. Can you give us the state of the Court of Appeals today? What is the makeup of it? And why is it important in this coming election? What's the critical issue with regard to it?
So the Court of Appeals, the first Court of Appeals that I'm running for, has 9 judges.
How many total Court of Appeals are there if this is just the first?
Yeah, there's 15. There's 15
and just
courts.
one of them has 9 judges.
Several of them have 9 judges. The first Court of Appeals has 9. The bigger in terms of population, all of this is set by the legislature, but the first Court of Appeals has 9 judges because it has a pretty big area. It has those 10 counties.
And this is only civil matters, correct? There's a whole other Court of Appeals that's criminal, right?
So Texas is interesting. It goes, you have the district courts, which some of them here are civil, some of them here are criminal. And then if you have an appeal, the appeals court hear all appeals, both civil and criminal. And then if you go up, if you have a criminal appeal to the Court of Criminal Appeals, that's the Texas Supreme Court of Crime, the Court of Criminal Appeals. And then the Texas Supreme Court hears all civil cases. So the Court of Appeals that I'm running for, the first Court of Appeals, hears civil, criminal, everything. So 9 judges. None of them have a specialization in intellectual property law. There's several former prosecutors, all brilliant justices. There's still 2 Democrats left on, and I'm running against a Democrat to replace her, to replace one of the Democratic judges. She's a very liberal Democrat. So the Republicans have had a good year in 2024. 7 of the 9 justices on the first Court of Appeals are Republicans, but none of them have any specialized knowledge about intellectual property law.
Well, looking forward to hearing about this race, and we certainly got a good education on intellectual property law I do appreciate your time. Can you tell us where people can learn more about your campaign?
Yes, please. So my name is Malcolm Whittaker, and I am running for the first Court of Appeals, Place 3. I have a website, malcolmforjudge.com. That's MALCOLM and then FOR and then judge.com, malcolmforjudge.com. I'm on Instagram at Malcolm Whittaker for Judge. That's my first name, MALCOLM WHI, two T's, AKER, FOR Judge. And then I'm on Facebook and also on X. And I hope you'll remember Malcolm Whittaker for the first Court of Appeals. My primary is March 3rd of 2026. So I'm in a contested race. So I really would love to have everyone in Fort Bend's vote, or all the Republicans votes in order to win my primary and then to defeat the very liberal Democrat who currently holds the seat in November of 2026.
Very good. Well, thank you very much, Malcolm. I appreciate your time. It was a great hour. We certainly learned a lot. I feel like it was an education in itself. So appreciate what you did here today, and I look forward to hearing more about your race.
Thank you so much, Chris. Thank you
Have
for
a great
having
day.
me on. I really do appreciate it.
Thank you.